Hello friends, I am Sanjana Mithil, partner with the ERA Legal Consultancy and Law Coaching. Today's lecture will be about a brief overview of the contents of the Indian Contract Act. Now the speciality of the Indian Contract Act is that it is a subject, it is something that lays down the guiding principles with regard to formation of a valid contract. It doesn't lay down any law as such, but certain guiding principles subject to which a contract will be considered valid, void or voidable. In order to understand the entire significance of the Indian Contract Act, we need to understand in detail the various stages a contract undergoes. For the purpose of the same, I would like to take you to the board. If you can see the board over here, on the board, there is an entire chart which talks about the various stages of the contract. For anything to take a journey of the process, it needs to first be formed. Hence, but obviously the first stage will be formation of contract. Once the contract is formed, the next stage is the execution or discharge of the contract. Execution or discharge means the manner in which a contract will come to an end. Now a contract can die its natural death, that is, it can be duly performed and be done away with, or there may be other circumstances such as breach of contract, the contract being put to end, that is rescission of the contract by mutual agreement, novation of the contract, so on and so forth. The other aspect through which the contract may be put to an end is by operation of law. So this is what we will be looking at in this particular stage of the contract. The third stage, as you can see, are the enforcement procedures or the remedies that are available in case the contract is not discharged by performance. So it's very natural if you enter into a particular contract with a person and both you and the other party are willing to perform their end of the bargain and have duly performed the contract, there is no foul play over here and the contract is performed and hence discharged. The problem arises when either of the parties fail to perform their end of the bargain. It is then that any of these remedies may be sought by the aggrieved party against the party who has breached the contract. So this is what we will be covering under this particular head. To begin with the entire lecture, the first stage, as I told you, is formation of contract. The whole concept of a valid contract begins from the concept of offer. Offer means a proposal. Some offer is being given to the other party. When that offer is accepted by the other party, the consequence is a promise. Once a promise is made, the person which gave the offer becomes the promiser. The person who accepted the offer becomes the promisee. So this is the first stage. Offer is given by one person X to another person Y. The Y person will either accept it or reject it. If the Y person accepts it, there is a promise that has come into being between the two parties as of now, whereby the offerer has become the promiser and the offeree has become the promisee. Once there is a due consideration from both the sides with regard to that promise, that is, there is a consideration that is added to the promise takes the shape of the agreement. This agreement, as per section 2H, when enforceable by law, turns into a valid contract. So, what is a valid contract? A valid contract is an agreement enforceable by law. What is an agreement? An agreement is a promise with a consideration. What is a promise? A promise is a combination of offer and acceptance. In a nutshell, offer plus acceptance is equal to promise. Promise plus consideration is equal to agreement. Agreement, when enforceable by law, becomes a valid contract. So this is what we have seen in this particular question up until now. Now, what do we understand by the term enforceable by law? What is enforceable by law, or when does a contract become enforceable by law, are the conditions that have been laid under section 10 of the Indian Contract Act. Now section 10 is the jargon, is the basic backbone of the entire Indian contract general principles for that matter. Every valid contract when made in India will have to go through a touchstone of the essentials provided under section 10. The essentials provided under section 10 are these. First of all, there have to be two parties to enter into a contract. So, a person cannot enter into a contract with himself. There has to be any other person to whom the offer has to be made and who has to accept that particular offer. Not only these, both these parties have to be capacitated. They have to be capacitated to enter into the contract. Now, what is the capacity of the parties? As per section 11 read with section 12, a person cannot be a minor, a person cannot be of unsound mind, and a person cannot be barred by law to which he is subject for the time being to be capacitated or to have the capacity to enter into the contract. Second element that is covered under section 10 with regard to essentials is the free consent of the parties. Now, Indian Contract Act gives two concepts, consent and free consent. Consent means consensus ad idem, that is agreeing on the same thing in the same manner. This is a basic prerequisite which has to be there. Another prerequisite is that not only the consent should be there, this consent should be free consent, that is both the parties should have entered into the contract freely, with their own volition, with their own will to enter into the contract. According to section 14, a consent is said to be free when it is not caused by fraud, misrepresentation, coercion, undue influence and mistake. If there is any of these elements present in the contract, that is the other party has either caused the first party to enter into a contract by fraud, by coercion or by undue influence or misrepresentation for that matter, the contract will be voidable. Mistake, though comes within the ambit of the absence of free consent, has a slightly different impact, which is to render the contract void based on the nature of the mistake, and the same has been elaborated under section 18 to 22. So that is what free consent of the parties is dealt with over here. Third topic and a very important aspect of a contract is lawful consideration. Now, consideration as defined by section 2 clause D is when at the desire of the promisor, the promisee or any other person has done something or has abstained from doing something, does something or abstains from doing something, or promises to do something or abstain from doing something, such promise, such action or abstinence is known as consideration. Not only should there be a consideration always, as per section 25, any agreement without consideration is void ab initio. So there has to be a consideration moving from both the parties, but also that consideration should be legal. So if X person enters into a contract, into an agreement with a Y person to kill a Z person, and for which the X will pay rupees 10,000 to Y person, that is considered as a illegal consideration. The consideration moving from the part of Y is killing of Z. So that is not lawful. Since that consideration is not lawful, the contract, the agreement will never nurture into a contract. It will die at the stage of agreement only. It will be an agreement void ab initio. So lawful consideration is something that is very important for a agreement to materialize into a contract. Next stage that you can see over here is that of a lawful object. Now, lawful object and lawful consideration are often confused by the people and they tend to overlook this idea of lawful object. Let's take an example over here. X enters into an agreement with Y, saying to him that I will give you 100 rupees per day, and for those 100 rupees you will buy peanuts and you will feed those peanuts to Z. Now, when X is making this proposal to Y, X knows fully well that that Z is allergic to peanuts. As a result, if Y will feed peanuts to Z, Z will definitely succumb to the peanuts, allergy of peanuts, and eventually die. Over here, the agreement is, if you will look at the agreement as such from the viewpoint of the consideration, agreement is nothing but a very simple thing. You will buy peanuts, I will pay you money, and you will feed peanuts to Z. There is nothing illegal in the consideration over here. But the object of the agreement is to succumb Z to the allergy of the peanuts. Hence, the object over here is unlawful. In that case also, the agreement between X and Y will become void or void ab initio or non-enforceable as such. Not expressly declared to be void by any law for the time being. So, this term particularly refers to two kinds of law over here. Law in the term of Indian Contract Act. So, any agreement should not have been declared to be void by the Indian Contract Act itself. There are certain instances whereby Indian Contract Act lays down certain agreements which will be void. For example, your wagering agreements or your agreement with a minor. So, there are certain categories which have been laid down to be void by the Indian Contract Act itself. So, if there is an agreement which has been declared to be void by Indian Contract Act or any other law which is in vogue, which is being practiced in the country, if any particular agreement has been declared to be expressly void by it, even that agreement, even though it may fulfill all the other criteria, will be considered as void ab initio. So, I hope I have made my point clear over here that in order to the journey of offer to a valid contract, the journey of offer to a valid contract undergoes various stages. It turns into a promise, it accompanies the consideration to turn into an agreement, and finally it has to undergo the touchstone of these all essentials to finally culminate into a valid contract. Absence of any of these essentials will either render the contract voidable, that is, which can be repudiated at the option of one of the parties, or it will render the agreement void, that is, an agreement which is not enforceable at the option of either of the parties. So, a contract, a valid contract is a contract, an agreement which is enforceable by law at the option of both the parties. Alright, so an agreement to be valid contract has to be enforceable at the option of both the parties. So till now we have talked about what happens when there is a formation of a contract. A contract ban gaya, we are done with it. Okay. The next stage that we are looking at is the discharge of the contract. Once there is a contract between the two parties, the contract will either be performed by the two parties, both the parties, or it will not be performed by either of the parties, or it will not be performed by both the parties, or there may be certain external circumstances which will make the performance of the contract impossible. So this is what we are looking at over here in discharge. Performance being the first category. Performance is when both the offerer and the acceptor are willing to perform their end of the bargain or have already tendered the performance of their end of the consideration. So there over here, the entire Indian Contract Act, in the Indian Contract Act, section 37 to 67 lay down various criteria, various circumstances with regard to performance of the contract. It encompasses reciprocal promises, it encompasses joint promises and various other criteria such as time of performance, place of performance, appropriation, etc. So the entire issue is covered under this topic of performance of contracts. The second topic that we look over here is breach of contracts. Now breach of contracts is where, breach is the term where one of the parties has either made it impossible or unlawful to perform the contract. So one of the parties is over here not going to perform their end of the bargain, then it is known as breach of contract. Under Indian Contract Act, breach has been classified into two parts, actual breach or anticipatory breach. Anticipatory breach, as the term suggests, anticipatory, is when there is an anticipation that on the due date the contract will not be performed. So on the actual date of performance, the contract will not be performed. This anticipation is there beforehand, then it is known as anticipatory breach of contract. If there is anticipatory breach of contract, the contract gives two options to the parties to either repudiate the contract, resign the contract on the date of anticipatory breach, or wait till the actual date of performance. If the party elects to resign the contract on the date of anticipatory breach, that is also the option. If it waits to elect, then the remedies with regard to actual breach will be applicable in the case. The second thing that I told you about is the actual breach of the contract. Now, actual breach of the contract is when on the due date of the performance, either of the party fails to perform their end of the bargain. That will be known as actual breach of the contract. Okay, so this is what breaches, and the Indian Contract Act lays down various remedies for anticipatory breach as well as for actual breach. Third is the mutual agreement. Now, it may so happen that neither of the party wants to go ahead with the contract. They don't want to go ahead with the contract, in which case they will mutually agree to put an end to the contract. Rescission is different from the actual breach in the sense that in rescission, there is no one-sided action. It is the mutual agreement of both the parties to terminate the contract. Whereas in breach, one party wants to go ahead with the contract while the other party has done something on their part to be unable to perform their end of the consideration. So this is the difference between actual breach and rescission by mutual agreement. Another format by which the contract can be put an end to is novation. Now, when there is novation, the term novation means something new has been brought about. So, say for example, X and Y enter into an agreement whereby X agrees to buy 10 kg of rice from Y for rupees 1000. At a later date, X feels he doesn't need rice anymore, instead he needs wheat. So, what he does is, he goes to Y and he says, look bhaiya, I don't want rice anymore. Will you give me wheat for rupees 10,000? 10 kgs of wheat for rupees 10,000? Y says fine. I will not give you rice. Instead, I will give you wheat for rupees 10,000. Now, over here, what has happened? Will now Y be able to claim any damages against X because he did not buy wheat, rice? No, because they have put an end by mutual agreement to the previous agreement of rice, and instead, by novation, they have brought about a new agreement of buying and selling wheat. So, novation is the change in the material terms of the agreement, so much so that the previous agreement is put to an end and the new agreement which has been brought about between the parties now becomes enforceable. So, this is what is the discharge of contract by mutual agreement means. That being said, there is another topic of operation by law. Now, operation by law is where, say for example, X enters into an agreement with Y to paint Y's picture. But before the actual date of performance, before he can complete the entire portrait, X dies. In such a case, or X goes mad. In such a case, will Y be able to compel, if X goes mad, to draw that picture, to draw that portrait, or in case X dies, will Y be able to force the legal heirs of X to perform the agreement or the contract? No. Why? Because it was a contract of personal service which could have been done only by X. And X having gone mad or died, the agreement becomes enforceable by operation of law. Similarly, if X goes insolvent or X becomes a convict, in all these cases the contract will not be performed. So, these criteria under operation of law, even though have not been expressly laid down under the Indian Contract Act, do have the effect of discharging the contract. Another aspect whereby the contract will be discharged is by frustration. As I told you when I was starting this topic, when I had just started this topic of discharge of contract, that contract can also be discharged by effect of certain external circumstances. Now, let's say for example, X enters into a contract with Y, whereby X rents Y's gallery, space, house with a window to see a procession of Shah Rukh Khan's convoy which is going to pass through the road in front of X's house, Y's house. What has X done over here? X has entered into an agreement with Y whereby X has borrowed Y's space, parking space let's say, to watch Shah Rukh Khan's convoy passing from the road in front of that parking space. There is a proper agreement, there is no issue with it, both of them are adults, they have agreed whereby X is paying the money and Y is giving him the space. Perfectly alright, no issues. Now let's say Shah Rukh Khan cancels his convoy on the date of agreement. He doesn't come only with his convoy. What will happen in this case? Is it X's fault? Has he caused the breach? No, he was willing to pay the money. Is it Y's fault? Has he caused the breach? No, he was willing to pay the space. But has the agreement been performed? No. There is no performance of the agreement over here. Why? Because of certain external circumstances which have put an end to the contract. So this is known as whereby when the contract is valid at the time of formation, but due to certain external circumstances, the contract can no more be performed or it becomes void. This is known as frustration of contract. So even that is a mode which will discharge the contract. So I hope this point is clear to you with regard to discharge of the contract. So we've completed the two stages of the contract. The last stage that we are going to talk about is the enforcement or the remedies with regard to the contract. Now when we talked about the discharge over here, we saw that when there is performance of the contract, there is absolutely no issue whatsoever. But what happens when there is a breach of the contract? If there is a breach of the contract by any of the parties, be it anticipatory or be it actual, the other party, the aggrieved party, has an option to go to the court and demand any of these remedies. More specifically, the first remedy and the second remedy is demanded in case of actual breach. So, for example, let's say X enters into an agreement with Y whereby X has to sell his laptop to Y for rupees 50,000. On the due date, on the date on which the sale has to go through, X refuses to sell the laptop to Y. What remedy will Y have? Y will go to the court and ask the court to either require X to sell the laptop or in lieu of it, in alternative to that, pay the compensation to the tune of damage that has been incurred by Y due to that sale not having been brought about. The concept of damages that Y is going to ask, the remedy of damages that Y is going to ask is provided for under section 73 to 75 of the Indian Contract Act. And the remedy of specific performance of the contract has been provided under section 10 of the Specific Relief Act. Prior to 2018 Amendment Act, the remedy of specific performance was a discretionary remedy which lay with the court, and the court, if it felt that the damages would suffice to give the remedy to the other party, would not order specific performance. And so, in that case, only damages was the most active rule or the most active remedy available with the aggrieved party. However, after 2018 Amendment Act to the Specific Relief Act, the specific performance has become a rule, and whenever a party will approach the court for the breach of contract, the court will first order specific performance of the contract, and in case there are certain criteria whereby the contract cannot be performed, if the nature of the contract is such that it cannot be performed, and which has also been elaborated under section 14 of the Specific Relief Act, only in that case the court will award damages. Or if the other party, the aggrieved party, has only claimed damages, then the court may award damages. Otherwise, as a rule now, the court is required to order the specific performance of the contract and not damages. That being said, injunction is mostly a remedy which is available in the case of anticipatory breach. So where the party is aware of the fact that the other party is about to breach the contract on the date of performance of the contract, the party, when it comes to know about the anticipatory breach, can approach the court to either rescind the contract and claim the damages, or it can require the court to pass the injunction stopping the other party from breaching the contract. So this is where the remedy of injunction comes into play. The temporary injunction is dealt with under the Civil Procedure Code, and the permanent injunction is covered by the Specific Relief Act. Last remedy that we have over here is quantum meruit. Now quantum meruit means the payment for whatever work you have done. It may so happen, not always, it won't so happen that the contract hasn't been performed at all and it has been breached. It may so happen that one of the parties to the contract has already performed some portion of the contract, and after that the other party breaches the contract or repudiates the contract. Just say for example, X enters into an agreement with Y, whereby X says to Y that you will write a book for me and for that I will pay you this amount of money. Y agrees to it, Y starts writing the book, and while he is halfway through, X goes to Y and says, sorry, I don't want to go ahead with the book. Please stop writing, I don't want your book. Over here, Y has already done a part of his work, but even Y has not done his entire work. So what amount of damages will Y claim? What amount of damages, what amount of compensation will Y get will be covered by the remedy of quantum meruit. The remedy of quantum meruit has been elaborated under various sections of Indian Contract Act, though not in so many words, but the concept lies therein, specifically under the sections of 64 and 65, which are restitution remedy sections requiring the other party to restitute any advantages gained under a void or the voidable contract respectively. So quantum meruit is a remedy that is made available to the parties under the section 64 and 65. Also, quantum meruit is a remedy which is a parallel term for the damages in the case of quasi-contracts. So under quasi-contracts, instead of application of damages term as such, we identify the compensation based on the theory of quantum meruit. Unjust enrichment is the problem and quantum meruit is the resolution to the same. So this is the entire scene of the stages of the contract. The contract began with the offer, it culminated into the contract, it was either performed or discharged by any other means. If there was breach, the contract ended up, we have remedies that were given under the Specific Relief Act and the sections of the Contract Act as well. So I hope I was able to put forth my basic outline of the Indian Contract Act. This is not everything to the Indian Contract Act, but yes, this is some basic framework to the Indian Contract Act over here. Apart from that, there are certain topics such as various types of contract, for example, your wagering agreements, your contingent contracts, etc. But your quasi-contracts, but those are the terms in themselves. This is something that covers the majority of the portion of the entire Indian Contract Act. Thank you so much for your time. I hope you enjoyed the lecture.